Calling at this time cause number CR 14,024. This matter styled State of Texas versus Eddie Ray Routh. The record will reflect that State's counsel is present at council table, as well as Mr. St. John, Mr. Moore, and Mr. Isom for the defendant. And the defendant, Mr. Routh, is present as well. The jury, having been sworn Monday, is outside the courtroom at this time. There are some matters that need to be addressed before we bring the jury in. The first question I have this morning is the state ready for trial?
State's ready, Your Honor.
Is the defendant?
Ready, Your Honor.
I was advised earlier this morning that we had a stipulation, a matter need to be addressed, and I'll do that at this time.
Yes, Your Honor. I'll show the court we marked State's Exhibit 229, stipulation of evidence regarding the autopsies performed by Dr. Bernard.
All right, Mr. Routh, I'm looking at State's Exhibit 229. This exhibit is a stipulation of evidence, and it stipulates that the persons that Dr. Jeffrey Bernard performed an autopsy on in Dallas relating to this case were Christopher Scott, Kyle, and Chad Littlefield. Do you understand that you have the right, the absolute right, to confront and cross-examine witnesses as to the stipulated testimony?
Yes, Your Honor.
You further understand that you're waiving the rights to confront and cross-examine the witness as to the stipulated testimony, and that by doing so, this exhibit will be admitted as evidence in this proceeding.
Yes, Your Honor.
You've had a chance to go over this with your attorney.
Yes, Your Honor.
You understand what it says.
Yes, sir.
It bears your signature where the blank is assigned for the defendant. Did you freely and voluntarily sign this instrument?
Yes, Your Honor.
All right, I will admit State's Exhibit 229 as a stipulation, being done so in open court. And I'll return this to the state at this time to be tendered to the reporter. Yes. Anything further by the state before we bring the jury in?
No, Your Honor.
The defense?
No, Judge.
All right, let's bring the jury in. Let me see. All right, you may be seated in the courtroom. Good morning, ladies and gentlemen of the jury. I trust that your luxury travel arrangements were okay this morning. I want to take a little bit of time again. I told you Monday that we had a little bit more to talk about, and I want to remind you of that oath that you took Monday. That oath By taking that oath and swearing in this case, you've become officers of this court and critical components of the system of justice that we have in our country. You have now become the voice and conscience of the community in this matter. By accepting that role, by serving in this case, you have an obligation now. That obligation is to maintain the integrity of the system. We need to ensure from this point forward that all the rules that we have in place and all the laws that we have are followed so that each side can have a fair trial in this proceeding. Again, I will remind you, this requires that you not communicate with anyone about this case. You cannot even communicate amongst yourselves regarding the case until I release you to deliberate at the end of the proceedings at the close of evidence. Again, I've provided a bailiff, and he's got staff to help you in this matter. Anything you need, you let him know. If you have any concern about any violations of any of the instructions we've got in place, you let him know and he'll let me know. We'll take care of it. If you need anything, let him know. He'll bring it to my attention. For example, sometimes I get busy and the attorneys get busy. If you can't hear something, raise your hand. If I'm not seeing it, see if you can get the bailiff's attention. He'll let me know. We'll stop it. We'll fix it. That's the sort of thing that we've got in place. I want to talk to you a little bit about what you can expect over the next few days of this proceeding. In a few moments, I'm going to have the state read the indictment in this case. From that point, the defendant will enter a plea to that indictment. Both sides will make opening statements. Once that's concluded, the state will present its case. When the state concludes that, the defendant will have an opportunity to present a case if he wishes to do so. If he does, then the state is entitled to present rebuttal evidence. If the state presents rebuttal evidence, then the defense has an opportunity to present additional evidence as well. Once that is completed, as I had told you about earlier, once all of the evidence is in, I will prepare the court's instructions, the law that I promised you each of you will get. I will read that to you, and I will provide every juror a copy of it. The attorneys will then be allowed to make closing statements, and you will be discharged to deliberate. At that time is when you can discuss the case amongst yourselves. And know that all jurors must be present at all times in the event that you've been discharged to deliberate. During the course of the proceedings, the attorneys may feel that it's necessary to make objections. Don't concern yourself with the objections or why I ruled the way I did. Simply be guided by this principle. You may consider evidence that I admit. You must not consider any evidence that I instruct you to disregard. I will try to ensure that we proceed orderly in this manner. Your job from this point forward is not to concern yourself with the law, but to decide the facts. You listen to the witnesses, decide what to believe and what not to believe, and any weight that you want to give or not give that testimony. You will do this, as the attorneys have repeatedly told you, by good judgment. That is your common sense and your everyday life experiences. I noticed that a number of you had notes. I have an additional instruction that I'm required to read for note taking. I'll do that at this time. Bear with me. I don't like to read to people, but I have to make sure this is exactly right, so I'll read it, and I do this every time. Ladies and gentlemen of the jury, because of the potential usefulness of taking notes, you may take notes during the presentation of evidence in this case. However, you may not take notes during the arguments of the lawyers or when the jury charge is read to you. Moreover, to ensure a completely fair and impartial trial, I will instruct you to observe the following limitations. Note-taking is permitted but not required. Each of you may take notes, however, no one is required to take notes. Take notes sparingly. Do not try to summarize all of the testimony. Notes are for the purpose of refreshing memory. They are particularly helpful when dealing with measurements, times, distances, identities, and relationships. Be brief. Overindulgence in note-taking may be distracting. You, the jurors, must pass on the credibility of witnesses. Hence, you must observe the demeanor and appearance of each person on the witness stand to assist you in passing on his or her credibility. Note-taking must not distract you from that task. If you wish to make a note, you need not sacrifice the opportunity to make an important observation. You may make note after having made the observation itself. Keep in mind that when you ultimately make a decision in a case, you will rely principally upon your eyes, your ears, and your mind, not upon your fingers. Do not take your notes away from the court. At the end of each day, please leave your notes in an envelope which will be provided for you. The court's bailiff will be directed to take the envelope to a safe place and return it at the beginning of the next session unopened. Your notes are for your own private use. It is improper for you to share your notes with any other jurors during any phase of the trial, even in jury deliberations. You may, however, discuss the contents of your note in deliberations, but they do not prove the matter asserted therein. You have those materials before you. I do want to caution you one more time. I'm going to ask you to listen carefully to the testimony. Jurors often have this misconception that after the presentation of evidence, after the case is closed, that you can deliberate and request readbacks of testimony. That is a mistake. That's a misconception. Readbacks are allowable. Let me tell you the circumstances. A jury can request that the reporter read back the testimony if it is a specific disagreement among the jurors as to a specific point. By example, witness X described the light as green. If you have a dispute among you if the answer was green or red, you can pinpoint that and the reporter can read back what the witness actually said. Short of that, there's no readbacks of testimony. In other words, I forgot what he said or I forgot what she said is insufficient. So listen carefully. At this time, that's all the instructions I have for you. I will have the state read the indictment for purposes of trial on the merits.
Thank you, Your Honor. Cause number CR 14024, State of Texas versus Eddie Ray Routh. In the District Court, 266 Judicial District, Routh County, Texas. Grand jury indictment. In the name and by authority of the State of Texas, the grand jury for the County of Routh, State of Texas, duly selected, impaneled, sworn, charged, and organized as such at the July term AD 2013 of the 266 Judicial District Court for said county, upon their oaths present in and to said court at said term, that Eddie Ray Routh, hereinafter styled defendant, on or about the second day of February AD 2013, and before the presentment of this indictment in the county and state aforesaid, did then and there intentionally or knowingly cause the death of an individual, Christopher Scott Kyle, namely by shooting him with a firearm, and did then and there intentionally or knowingly cause the death of another individual, namely Chad Hudson Littlefield, by shooting him with a firearm, and both murders were committed during the same criminal episode. Against the peace and dignity of the state, signed foreman of the grand jury.
All right, the indictment has been read at this time. How does the defendant plead?
I'll give it to Your Honor.
All right, you may be seated. At this time, I will allow the state to present opening statements.
May it please the court.
Yes, sir.
Counsel. Ladies and gentlemen, it is a serious matter we're here to deal with over the next few days, and you know that. You've been through more dire. You know the nature of the allegations, and you just heard the reading of the indictment. So it's clear what we are here to do is seek to prove beyond a reasonable doubt for you all the elements that were just described in that indictment you just read. We are tasked as the state to prove each of the elements contained in that indictment beyond a reasonable doubt. And we welcome that task. We will present evidence to you regarding each of those elements. In a sense, a lot of what we will have to present to you is to technically and mechanically prove beyond a reasonable doubt each of those elements, down to the county in which this crime happened, the date on or about this crime happened, and the other elements. But I welcome the opportunity now to preview for you not all the evidence that we will present, because it will be voluminous. You'll hear from a number of witnesses, many witnesses, about how this crime was committed, the conduct of the defendant before, during, and after commission of this crime. You'll hear all of that. You'll hear everything about where the county line is between Somerville County and Erath County. We will work through all of that. And you will decide whether we have met each of those elements on those mechanical parts of the case. But as I begin to preview the evidence for you, understanding what I say is not evidence, we're going to ask you to hear the evidence and let it guide you. But I do want to give you a preview of the core issues that we believe are in the case and what evidence we believe is going to address those issues. Yes, indeed, we believe the evidence is going to establish that in Erath County, on February 2nd, 2013, this defendant intentionally caused the death of Chad Hudson Littlefield, and that this defendant intentionally caused the death of Chris Kyle, and that he did so in the same criminal transaction. We expect to present evidence of all of that. But in the end, we believe the key evidence that's going to guide you is going to guide you on two critical issues. And that is, did he intentionally cause the death of these two men? And when he did so, did he know what he was doing was wrong? Those are the two ultimate issues we're going to ask you to decide. Now, as you learned in voir dire, the burden of proving the first question is upon the state. Every element of that indictment we have to prove. The key issue you're going to decide is when he shot these men, was it intentional and knowing causing his death? Did he intentionally or knowingly cause the death of Chad Hudson Littlefield? And did he intentionally or knowingly cause the death of Christopher Kyle? We believe the evidence is going to guide you that way. When you have concluded that, you're then going to decide, as the defense proved to you, that when he did that, when he intentionally caused these men's death, he had a severe mental disease or defect, which caused him to not know that what he was doing was wrong. Now, the Jane preview for you the other day, that is a very, very narrow door that they have to thread in order to convince you that once we have proven to you through our evidence, we think the evidence will guide you to this, once we have proved that he intentionally or knowingly caused the death of these two men, we have to hold him to that very, very narrow path for him to get away with that murder, those two murders that we will prove. That is a heavy burden to meet that they must meet for him to get away with these murders. So that brings me to one. Now, we're not going to preview every piece of evidence and every bit of testimony, but I do want to hit some of the important points that are going to be presented about, again, the defendant's conduct before this crime was committed, during the commission of the crime, and following the commission of the crime. Because the good news for you is you are people of common sense, and you get to use that common sense in analyzing those two issues. Did he intentionally cause their death? And when he did so, did he know what he was doing was wrong? Let's work through some of the evidence, and this is information that you should know at this point. And the evidence is going to step by step establish this. On the morning of February 2nd, 2013, Chad Hudson Littlefield, a daddy with a 7-year-old little girl, a son, a husband, and a brother, was having an ordinary Saturday. He planned to go have time out at a shooting sports range with his very best friend, Christopher Scott Kyle, a daddy to an 8-year-old little boy and a 6-year-old little girl, a husband, a son, and a brother. They've done this many times before. They were best buddies. And the evidence is going to show you that one of the passions that they had, one of the things they most enjoyed doing together, was befriending, spending time with veterans, people who have served. And they had planned that day to do that with a young man they had yet to meet, the defendant. We expect the evidence to show the defendant served in the Marine Corps for a number of years. We expect the evidence to show that he served in the green zone of Iraq. We expect in the safe zone as an armorer working on guns. He was very familiar with guns. He was a marksman. He knew how to use a gun. And then he also served at sea as a Marine on ships. And then he served in disaster relief in Haiti for a time, where he spent time on a ship awaiting service if needed. The job being an armorer, someone who works on guns. And he went down there. He got out of the military, and these men were approached by his mother, would you spend time with him? Would you befriend him? And that was their plan that morning, February 2nd, a Saturday. Two best friends are going to befriend another man and spend time with him doing what men like to do. That is, go out and be men. Shoot guns together, drive an hour and a half to get to a shooting sports range at a very nice lodge that, in Glen Rose of Routh County. They're going to spend time together. The evidence is going to show that morning the defendant was doing something a little different. The defendant was preparing for his day by smoking cigarettes, smoking dope, and drinking whiskey. They meet up that afternoon. We expect the evidence to show that sometime in the early afternoon, Chris and Chad got together and loaded up in Chris's truck. They loaded up a number of really neat firearms to take to the shooting sports range, spend time shooting, some rifles and some pistols and some revolvers, and they were going to have a good time with this young man and spend time with him. The evidence is going to show they picked him up they left Midlothian where they live, and they drove over to Lancaster, which is a city not too far away where the defendant lived. And they pulled up the driveway, the defendant got in the truck, and off they went. We will never know what all conversations occurred in that trip. It took about an hour. The trip was about an hour and a half, 2 hours from Lancaster over to Routh Creek Lodge. Some of you may be familiar with Routh Creek Lodge, which is just across the county line in Somerville County, and then a big part of that is in Routh County. And they go there, and it's a nice. You'll get to see pictures of what it's like out at Routh Creek Lodge. People with my pay grade sometimes don't get to go out there, but we've been out there and we have photographs for you to look at. And it's a very, very nice place. And they're going out there and they're going to spend some time. They drive out there. Don't know how the conversation went. There's just some evidence that they thought it was a little off. It was a little strange. No doubt about it. It was a little strange. Which we now know, what Chris and Chad didn't know, what he's been doing that morning. But he's a little strange, but they persist and they go on out to the range. They stop by the headquarters of this lodge. They check in. Chris Kyle was known there. Based on his past military service, he had helped design the lodge shooting sports range. And they stop. Chris checks in. They have a procedure for raising a flag so that people know they're at the gun range. And they drive a very short distance. They pass by some homes that are on the place and go down this public road and end up at the shooting sports range. And that's where what we'll hear about begins. We'll never know what conversations were had, what exactly happened between Chad and Chris, two best friends, and their interaction with this defendant. We won't know what was said, but we do know that a few short hours later, the evidence is going to show you that staff of the Routh Creek Lodge approached the lodge to check on things and to say hello, and the flag was still up. The truck was gone, and as they approached the shooting sports deck, they found Chad Littlefield, shot 4 times in the back, 1 time in the hand, once in the face, once in the top of the head. And they found Chris Kyle, shot 5 times in the back and side, and 1 time in the side of the head. The truck was gone. The defendant was nowhere to be found. We expect the evidence to show that law enforcement from Somerville County and paramedics arrived and staff from that Rough Creek Lodge heroically tried to save them, but there was no saving them. They were injured too badly. They would never have made it. As law enforcement from Somerville County arrived, they realized this was actually an ERAF county. So they immediately get the ERAF County law enforcement involved. To get them ERAF County law enforcement gets the Texas Rangers involved. And as they try to sort through the identification of these 2 men who had been murdered, they figured out the 3rd person was there and the truck was missing, and they began looking for him. We expect the evidence to show that after this man shot these 2 men, he fled. We expect the evidence to show that's his word. He fled. He shot these 2 men with different guns. Again, the evidence is going to show that he shot Chad Hudson Littlefield 4 times in the back using a 9mm handgun. And it's top, you're going to hear evidence from firearms folks and law enforcement about how these guns operate. There's a pistol that takes, when you pull the trigger, it's not like a machine gun. It takes every bullet fired, takes a pull of the trigger. So the trigger was pulled 4 times, pumping rounds into his back. Another time in his hand, and 1 time in the face, and 1 time on top of the head. That was a 9mm gun. The evidence is also going to show that Chris Kyle was shot with a different gun, a .45 caliber pistol. It takes 1 pull of the trigger for each shot. 4 times in the back, 5 times in the back and side, and 1 time in the side of the head. 2 different guns. We expect the evidence to show that later, when the defendant was discovered and caught, he had in his possession a fully loaded 9mm pistol. And forensics is going to show that it was the gun used to kill Chad Littlefield. So, the evidence is also going to show that the .45 that was used to kill Chris Kyle was left on the deck at the shooting sports range right above the head of Chad Littlefield, and later bleeding. Before he left, the evidence is going to show the defendant dropped the magazine, the clip, out of the 9mm, and at some point loaded it back up full with 15 rounds of 9mm ammo, put the clip back in, loaded around into the chamber, and took that gun with him when he stole Chris Kyle's truck, the 2008 black Ford F-250. Stuck it down in the door. That's his conduct during the crime. The evidence is also going to show a little more conduct during the crime that's important for you to consider. We previewed for you that we expect the evidence to show that he shot these 2 men in the back. The evidence is also going to show there had been some shooting down the range prior to these murders. The evidence is going to show that a .38 special, which you'll be able to see, you'll be able to take a look at these guns and learn how they function. A .38 special cowboy-style revolver where you pull the hammer back and you pull the trigger, and you pull the hammer back and you pull the trigger, called a single-action revolver, had been shot down the range through 2 cycles. It holds 6 rounds. We found 11 shell casings. So it had been shot 2 times and it was up on the deck. Beside Chris Kyle's head, where he died, was a .45 long Colt single action revolver, another old cowboy style gun, and it had been shot 6 times. One of those you pull a hammer back and you shoot it. And they had targets set up down the range. This gun was found by his head. And in that gun were 6 spent shell casings, used up bullets. He had shot all the bullets out of this gun at the time that he was shot in the back by this defendant. Now, let's set how the crime was committed. The conduct after the crime is very telling as well. We expect the evidence to show that he fled the scene. He stole this 9mm pistol. But the evidence is going to show that Morgan meets the eye when it comes to this pistol. The evidence is going to show that this was a special 9mm pistol because it was the type of pistol issued to U.S. Navy SEALs in the military. It's called a Sig Sauer 226 Young K-25 for those of you who are interested in guns. It's a special gun, and what makes it special is it's identical to those issued to Navy SEALs. And on the side of it, it has engraved in it the anchor of the U.S. Navy. This defendant left the gun he used to kill Chris Kyle, a Springfield .45, and he took the U.S. Navy issue gun with the Navy anchor on the side after he reloaded it. After he dropped it, while these 2 men lay there bleeding, he reloads the gun to full capacity and takes it with him. But there's more conduct we expect the evidence to show after he left. He goes through the fairly intricate layout of Rough Creek Lodge to get out of Rough Creek Lodge, and then he goes to his uncle. And he shows his uncle his new truck. And he shows his uncle his new guns. He had in his hand the revolver with the Navy anchor on the side, and inside the truck already was a rifle that he had with him. And he showed these guns to his uncle. And then, somewhere along the way, we expect the evidence to show he stops and has a burrito at Taco Bell. And then he goes to his sister, and that's where the police start figuring out who he is and where he is. He stops by his sister's house and shows her his new truck and starts to show her the new guns. When she asks him, "Where'd you get this stuff?" And he tells her, "Well, I murdered 2 men. I just murdered 2 men." She becomes quite upset, and she dials 911. And we expect you to hear what she said on that 911 call. In that 911 call, she's very upset because she just learned, obviously, that her brother has just murdered 2 men, stolen a truck, and stolen guns. She's hysterical. She calls, she talks about how he's acting psychotic. She's asked, "Is he on drugs?" And with a knowing pause, she says something to the effect of, "Maybe, I don't know." But to her credit, she lets law enforcement know before he takes that 9mm that's in the console of the truck, in the door of the truck, loaded with 15 rounds, ready for battle. She's smart enough and wise enough to call the police to make sure he doesn't hurt anybody else. And then she flees her home so he can't come back and see her because she's scared of him. He's just murdered 2 men. The evidence is going to show that then he goes to his house and he has told his sister he plans to flee to Oklahoma. The evidence is going to show that he goes to his house, he picks up his dog, and we don't really know what other purpose he might have had, and he leaves, and apparently he forgot something, because after he picks up his dog at his house in Lancaster, the police arrive at his house and are looking around trying to figure out if he's been there or going to be there, and he returns. And he returns in Chris Kyle's 2008 black Ford F-250. He's got the truck. he's got Chris Kyle's truck. This, we now know, this man was there, because he has the truck. He has a rambling conversation with the police, trying to talk him into getting out of the truck. He's in control enough of his faculties that he knows if he gets out of that truck, he's going to jail. And you'll hear him talk about that. You'll also hear him talk strange. You'll hear him talk weird. And you will hear him refuse to lower the window or get out of the truck. And after this conversation he has with the police in Lancaster, he decides he's going to leave. And the chase is on. He flees from law enforcement. He attempts to evade law enforcement. He meanders through town, knows right where he's going. He ends up on I-35, headed north toward Oklahoma. In the interim, a courageous police officer in Lancaster takes his car and rams the truck at high speed as he speeds through the neighborhoods of Lancaster, Texas. We expect the evidence to show that is what brought the chase to an end, because eventually, on I-35, as Lancaster law enforcement pursues him at high speed, his truck gives up the ghost and finally expires, based on having been damaged by that courageous police officer. The evidence is going to show, you'll get to see it yourself, you can form your own conclusion, but the evidence is going to show at this point, he's got a loaded 9mm gun in his door, but he knows those police don't have it back. The jig is up.
That's your proper argument, Judge. That goes inside the presentation of opening statement, I object.
Sustained.
At that point, with the 9mm in his door, the police issue commands to him over a loudspeaker while pointing weapons at his car. He sticks his hands out the window. He gets out of the truck. He gets down on his knees. He cooperates with the police. That's what the evidence will show. You can form your own conclusions. That's fair. The evidence will guide you. That's his conduct after the offense. You know, we talked about in the board hour, as you did with Jane, about different things that indicate intent. You talked about those with me, and then you talked with Jane about what actions indicate knowledge the conduct was wrong. That's what I wanted you to think about, and I asked you to think about as you hear the evidence that we've just previewed for each of you. I was previewed here this morning. But what happened does not end there. He's in custody at that point. This man who has murdered 2 people and gone on a wild high-speed chase is now in custody. And he is interviewed by a Texas Ranger, wherein he admits, he confesses that he's killed these 2 men. And he confesses that he had used drugs that morning, what he described as marijuana, possibly wet. Terms like Purple Hearts, drug terms. Talks about that very morning having used drug that was possibly wet with possibly formaldehyde. Those of you who aren't familiar with drug terms, those are new terms to me too. You'll hear evidence explaining what those terms mean in the drug world. But he used this wet marijuana that morning, and he drank whiskey with it. But he admits that he murdered these 2 men, that he used drugs and alcohol that morning, and that he knew what he was doing was wrong. Now, ladies and gentlemen, I submit to you, once we reach that point in the evidence, that establishes, that will establish for you all the elements that we have read to you in the indictment, that this man intentionally or knowingly caused the death of Chad Littlefield and Chris Kyle. But we also expect you to hear evidence about other issues as well. So let's go ahead and confront those issues head on. Let's talk about mental illness. You're going to hear the defendant from back then, from February 2013. You're going to see photos and videos of him from February 2013 that look drastically different from what you see before you here in the courtroom. Side by side, you might not even recognize him. The evidence is going to show you that this man has a history of dealing with various diagnoses of a variety of mental illnesses. You're going to hear words from VA records and expert testimonies such as schizophrenia, and PTSD, and psychosis not otherwise specified, and personality disorders, paranoia. You're going to hear these terms as a variety of doctors over the time since this man has been home has had labeled upon him. All those terms have been used in connection with this man at some time, in connection with him getting benefits, financial benefits from the VA, or him being treated by the VA. You're going to hear evidence about all those things. And you're going to hear where a variety of different doctors at the VA, a place called Green Oaks, and experts that may be called to the witness stand have used terms like schizophrenia, PTSD, psychosis not otherwise specified, personality disorders, paranoia. You're going to hear that. They're going to present you testimony from psychologists and psychiatrists that they have brought in to testify. We're going to present you psychiatrist and psychologist testimony. What I ask you to do is listen to both. Listen to both. Once you've listened to both, listen to all the evidence. We're still going to come back to the core issues. Did he intentionally or knowingly cause the death of the father, husband, son, brother, Chad Littlefield? And did he intentionally or knowingly cause the death of the father, husband, son, brother, Chris Kyle? And did he know what he was doing was wrong? And that mental illness issue, we're not concerned, because we can confront that with evidence that this defendant knew what he was doing was wrong. You'll hear all this expert testimony. You're going to hear a variety of terms used. Doctors trying to figure out why is this defendant why he is, and why does he do what he does. Well, let's be real about this. Mental illness does not take away your ability to know right from wrong. Mental illness is...
Pardon me, that is actually an argument for closing, and that is improper. Opening statement, I object.
Sustained.
I'll ask you to consider, as you hear the evidence, ask the question, does having a mental illness rise to the level that this defendant doesn't know right from wrong? I ask you to consider that as you hear the evidence. You'll reach your own conclusions. You're the ones with control here. But I ask you to consider that. Is it an issue that mentally ill people can't handle themselves? I think the evidence will guide you. When you hear from professionals in the field, you'll learn that the evidence will show that mental illnesses, even the ones that this defendant may or may not have, don't deprive people of the ability to be good citizens, to know right from wrong, to obey the law, and at the very least, not murder. We think the evidence is going to guide you there. And that's what we ask you to consider as you hear all of this evidence. Listen to all of it. Listen to their experts. We welcome you listening to their experts. Listen to the testimony about his prior diagnosis, and you'll see, I can assure you, you will see in the video interviews with him, his conduct in the roadside at Lancaster, this man has issues. I think the term used for folks like him is trouble. I think you'll hear testimony. This is a troubled young man. But always, as you hear that testimony, come back to those two core questions. Did he intentionally or knowingly cause the death of these two men? And when he did so, does his conduct before, during, and after, does that show that he knew what he was doing was wrong?
Mr. St. John.
Mr. Moore will.
Mr. Moore? Yes, sir.
ladies and gentlemen. I have not had a chance to address you. My name is Tim Moore. I live and work in Fort Worth, and I am honored to stand before you representing Eddie Routh. I've represented several clients down in Routh County before, and it was one of my favorite places to live. Y'all are great people, and y'all can be very proud of you county. On February 2nd, 2013, an absolute tragedy happened down Rough Creek Lodge, south of town here, about 20 miles. Gathered that day there were Kyle, Chad Littlefield, and Eddie Routh. They weren't there as buddies meeting to kick around old times and shoot guns and reminisce about days gone by. They were there because Eddie Routh was a troubled veteran. He had had mental health issues, and Kyle and Chad Littlefield were kind enough to try and help him. And the tragedy that occurred down there is that while they were attempting to help him, he took their lives. But when he took their lives, he was in the grip of a psychosis. A psychosis so severe at that point in time that he did not know what he was doing was wrong. In fact, he didn't not only know it was not wrong, he thought in his mind at that point in time that it was either him or them. That he had to take their lives because in his psychosis he was thinking they were going to take his. Now, to get to February 2nd of 2013, why that may have happened, we have to go back a few years and look at what happened in between. Eddie Routh, mother and dad, Jody and Raymond, raised him over in Lancaster, Texas. He was an average student, an average kid. He graduated from high school in 2006 and wanting to follow in his father's footsteps and serve his country. Immediately upon graduating from high school, he joined the Marines. And as Mr. Nash told you, he went through boot camp. He served his country in Iraq. He served his country at sea. And then in 2010, when the Haiti earthquake happened, he was sent on a rescue mission there where folks will tell you his experience in Haiti probably affected him more than any experience in Iraq. But nevertheless, Eddie was honorably discharged from the Marines in June of 2010. And he came back to Lancaster, his hometown, to live with his mom and dad. And you'll find that as many veterans that come back from Iraq or service in our country, they noticed that Eddie was a changed guy. He had a drinking problem, probably too much smoking marijuana. But he was changed, and people will come and tell you how he was a changed person, that he was having at that time mental health problems. And he was having such problems that they culminated in July of 2011. He was first admitted to the VA hospital over in Dallas. The VA hospital over in Dallas admitted him, and their diagnosis was psychosis. Psychosis, a severe mental disorder. In fact, at that time, you'll find that Eddie thought he had a tapeworm. He was convinced he had a tapeworm that was eating the insides out of it. So they take him to the VA hospital in July of 2011, and they not only determine that he has a psychosis, he's crying uncontrollably. They put him on antipsychotic medication. A doctor in the VA hospital puts him on antipsychotic medication, and they turn him loose. He goes back to live with his parents. A short time later, he's readmitted. He's readmitted to the VA hospital, again with a diagnosis of severe mental problem, a psychosis. They change his medication around, but leave him on antipsychotic medication, and he does fine for a while, works at odd jobs around, but then in September of 2012, before that, in August of 2011, back to the VA hospital.
Mr. Moore, one more.
What is that date? July what? Is that 2001?
2011, I'm sorry. This one right here? 2011. In August of 2011, he's readmitted because he's suicidal. They medicate him some more, release him again. He does some odd jobs. He's living with his folks. And then in September of 2012, he is suicidal to a point where he's walking down the road and the police have to stop him. The parents have called, said he's threatened to kill himself again. The police stop him. They don't take him to jail. They take him to the Green Oaks Hospital in Dallas. A Green Oaks Hospital in Dallas is a psychiatric hospital. He is admitted to Green Oaks, and then they transfer him over to the VA again. So in September, he not only goes to Green Oaks, they transfer him, and there they say he has a major depressive disorder with psychotic features, and again release him on antipsychotic medication. He had met a lady named Jennifer Weed back in April of 2012, and they had become boyfriend and girlfriend. After he left Green Oaks and the VA hospital in 2012, he went to live with Jennifer Weed in Dallas and her roommate. On On January 19th of 2013, Eddie had a psychotic episode in Jennifer Weed and her roommate's apartment. He held them, and he got some sword and a knife and held them in the apartment, wouldn't let them leave, was saying delusional things. Finally, the roommate texts the police. They come. They don't take Eddie to jail. They take Eddie back to Green Oaks. And at Green Oaks, on January 19th of 2013, the people there, the doctors there, give him a diagnosis of psychosis, that he is mentally ill, that he is likely to cause serious harm to himself or others, that he has severe abnormal mental, emotional, and physical distress. That was their diagnosis on January 19th of 2013. Well, he's transferred back to the VA hospital where he is treated for 4 or 5 days. On January 25th, the VA hospital, after diagnosing him with severe mental illness, gives him more psychotic medication and decides to release Eddie Routh. Jody Routh, his mother, Eddie's mother, begs this, please don't release Eddie. I've talked to him. I've seen him. He's not ready to be released yet. Oh yes, he'll be fine. Just have him take his medication. Have him take his antipsychotic medication, and he'll be fine. Well, they release him, and he goes to live with at his mom and dad's house. And he is working at a cabinet shop for a family friend, Donna Taylor, who you will hear from. And he's not doing too well. He's staring off into space and paranoid of his co-workers, thinking that they're out to get him. This is his state of mind. On February 1st, the night before this tragedy happened, Jennifer Weed spent the night with him. And Jennifer Weed will tell you that he was acting strange that night. He actually proposed to her that night. Asked her to marry him. And she accepted, but she'll also tell you that night he was seeing things, he was hearing things that weren't there. That he was telling her not to talk out loud and write things on paper because people were listening somehow. And so after a fitful night of sleep, she'll tell you that he didn't sleep much at all. They get up the next morning on February the 2nd, and all of a sudden Eddie tells her to get out. Leave, I don't want you here anymore. So she goes, okay, and she calls Uncle James, who comes over to try to calm Eddie down. They may smoke a little marijuana, and they have had a little alcohol, but this was in the morning. That's what the evidence would show. That was in the morning. And Uncle James will tell you that they hear a truck drive up, a loud truck, and hear walking, and Eddie, that's Chris Kyle. And Uncle James will tell you that the next thing he knows, he hears the truck drive off. Eddie hadn't said bye, hadn't put his dog up, hadn't locked the house up. They're just gone. From Lancaster to Routh Creek Lodge is about an hour and 40-minute drive. It's a pretty good drive. And if you know where Routh Creek Lodge is, it's down south of here, and it's out in the middle of nowhere. And Eddie is in the back of the truck. He is in the back seat. Chris Kyle's driving. Chad Littlefield's in the front seat. Eddie is back with these guns, and they have an arsenal. You'll see the pictures. There's assault rifles, and there's handguns and ammunition to support a small army. And Eddie's sitting in the back seat with this, going 80 miles an hour out in the middle of nowhere. And Mr. Nash is right. We don't know what the conversation was in that truck, but we know this. About an hour and a half into the drive, Chris Kyle was sitting in the driver's seat on his telephone, and he texts Chad Littlefield sitting right next to him. He texts him this dude is straight up nuts. This dude is straight up nuts. This is about an hour and a half into the drive. And Chad Littlefield texts Chris Kyle back, "He's right behind me, watch my six." So while we don't know what the conversation was, we do know what Chris Kyle was thinking at the time that he was in that truck with Eddie Routh. And we know what Chad Littlefield was thinking. And they get to the Routh Creek Lodge, and you'll again see the pictures of all these weapons that are laid out. They're shooting their guns and doing what guys do, and Eddie's psychosis is kicked in. And the tragedy happens and he takes their lives. He gets back in Chris Kyle's truck, goes to Uncle James's house and says, "Oh, look at my new truck. Came along with the gun. The gun came with it." They spend just a few minutes there, and then he ends up going to his sister's house, Laura Levin. And Mr. Nash told you, well, he said he killed 2 men. Well, I believe Laura Blevins is going to come in and tell you what he said was that he had killed them before they could kill him. And that he was going to take their soul before they could take his soul. She calls the police and tells them that Eddie is psychotic, and she She is scared to death of her own brother. Eddie then takes Chris Kyle's truck and goes to his house back in Lancaster to get his dog. Well, by now the police know he's in the truck, what the truck looks like. They go to Eddie's house and there's Eddie sitting in the truck. And he is surrounded by Lancaster police. You'll see all this. And he's sitting in the truck and he is talking to Louisiana. And with all these police surrounding him, after about 30 minutes, he drives off. And after a short chase, Eddie is arrested. Eddie is taken to the Lancaster Police Department, and at about 11:30 that night, Ranger Danny Briley from the Texas Rangers, who's the lead detective in this case, comes in to interview him. And you'll see that interview, I anticipate. And you'll see Eddie Routh's demeanor. And you'll see his answers to seemingly straightforward questions. And you'll hear the delusional responses, the psychotic responses that he gives to Ranger Briley. Now, you know from everybody telling you that the state has the burden of proof to prove their indictment beyond a reasonable doubt. And if we assert the insanity defense, which I can assure you that's exactly our intention, then we have the burden to prove by a preponderance of the evidence that at the time of this tragedy, Eddie Routh was suffering from a severe mental disease that he did not know his conduct was wrong. And we're not only going to present all the medical records and the friends and family that saw him and saw his behavior, but we're going to present board-certified forensic psychologists and psychiatrists who have spent time with him, who have examined Eddie, who have given him all kinds of psychological tests, have looked at all the reports, looked at the facts, and they are experienced forensic professionals who have dealt with insane people, incompetent people, and they're going to tell you that in their opinion, at the time of this tragedy, that Eddie Routh was insane. That not only was he suffering from a severe mental disease or defect, not only did he not know his conduct was wrong, he thought he had to take their lives because he was in danger. That was his psychotic mental state at the time. And Mr. Nash has said, oh, what a narrow window that we have to fit this in. I don't know where a narrow window came. You're going to get a definition of what insanity is from the judge. And you're going to hear the evidence. And ultimately, you're going to determine whether by a preponderance of the evidence that 5149 greater weight of the credible evidence did we prove to you, to each and every one of you, that he was indeed insane at the time. That's all we have to do. And I believe once you hear all the evidence, and I ask you to wait and don't make up your mind until you've heard all the evidence. You will find that it will be maybe a tough decision for you. You will find that at the time of this tragic event, this tragic occurrence, that Eddie Routh was insane. same time and not guilty by reason of
All right, that concludes the opening statements in this proceeding. For clarification and so that we're all on the same page, if you're unable to see something, unable to hear something, if it's too hot or too cold or you need a break, those are the things that I can help you with. I want to make sure we can ask questions of witnesses or attorneys or anything like that. If they don't make it clear enough for you or their handwriting's bad, that's their problem, not ours. But I can procedural things, I can move things around and that sort of thing, but we can't go back and clean up testimony. I just want to make sure we understand that. The state has tendered a witness list today of witnesses that are present. I'm going to call that roll at this time. If the witnesses are in fact present and available, I need to get all of them brought in to the courtroom. I'm going to make sure that the cameras are not broadcasting anything at this point in time. We'll get all those witnesses identified. I'll administer the oath to those that are available, and I'll go over the invocation of the rule.